And good afternoon. This is Scotty Sykes with Sykes and Company. Today we have working with, not against PBMs. Of course, we have Jeff and Brad with Brown Fortunato Law Firm who are going to bless us with their expertise on this very important topic. And please throw in some questions. We want to make this engaging for everybody, so throw in those questions as you get them. And appreciate everybody getting on. But with that, Jeff, Brad, I'll let you guys take it.
Sounds good. Hey, Scotty, why don't you go to the next slide?
All right.
Next one. There we go. Yeah, folks, it's our pleasure to spend an hour with you today. I'm Jeff Baird, and I'm with my partner, Brad Howard. We head up the healthcare group for Brown Fortunato. We're a Texas-based law firm, 16 attorneys in our healthcare group, and we work with pharmacies throughout the United States. We work closely with Alan and Scotty and Bonnie and their team, and I can tell you that they are absolutely the best. When it comes to accounting, the pharmacy industry is very fortunate to have Sykes and Company, and it's always an honor for Brad and me to be able to speak on behalf of Sykes and Company in a webinar. And from our standpoint, we certainly want to be on our A game, because we think the world of Scotty and Alan. Now, today we're going to talk about PBMs. And as you have questions, go on ahead and send them in to Scotty. This is as cheap as you're going to get an attorney. And so Brad and I will be more than happy to answer whatever questions you have. So just get them into Scotty, and Scotty will play Stump the Speaker. Now, PBMs, they're a challenge. They're the middleman. At the end of the day, you've got your insurer or your government program, then you've got your PBM, and then you got your pharmacy, and then you have your patient. And PBMs have a lot of power. Certainly there have been attempts in Congress, on the federal side, to try to limit PBMs' authority and power. That's gone nowhere. We are seeing state legislatures that are passing laws trying to limit some of the power that PBMs have. But this is kind of a slog. It's going to take time. But we as pharmacies, when we're dealing with a PBM, working with a PBM, it's important that this not be a zero-sum game, that we try to have a win-win type of arrangement. I know here at Brown Fortunato, when pharmacies come to us and they ask us, we're having this concern, this problem with Prime or CVS Caremark or ESI, what do we do? And here at Brown Fortunato, our approach is, let's solve the problem, let's make this win-win, let's not get into a spitting contest, because at the end of the day, the PBM has more leverage than we do, more bargaining power. There's no saying that possession is 9/10 of the law. At the end of the day, the PBM has our money. And so whether we're right or wrong, or it's right or it's wrong, if it's got our money, then it has a superior marketing position. And so, again, our approach needs to be win-win. The other reason that we here at Brown Fortunato, we try to avoid adversarial relationships with PBMs is because if a pharmacy client of ours and a PBM really gets into a cat fight, the PBM's got more money than God, and it can afford to lawyer up. And also, and then the nuclear option is that all of our contracts with PBMs have without cause termination. Mm-hmm. And so if a PBM doesn't like us, they can terminate our contract without cause. And so remember, possession is 9/10 of the law, and so let's understand that the best approach is win-win. Okay, Scotty, next slide.
And Jeff, so the thinking here is PBMs are there, you might as well make the best of the situation and try to make it a win-win situation, like you're saying. I mean, that's the mindset, that's the approach a pharmacy needs to be taken.
It really is, Scotty, and that's a good point. In fact, I'll turn. Let me ask my partner Brad. Brad spends a lot of time working with PBMs. I mean, what are your thoughts, Brad, about our approach in dealing with PBMs?
Well, I think Scotty's got it exactly right. It's a mindset. It's got to be a mindset of if you're going to win at the pharmacy, it can't be that the PBM is going to lose, because if it gets to be that confrontational, that combative, they can simply invoke their no cause termination and your contract is over. And then the problem that we see in the industry is a lot of times if you lose one contract, there's the domino effect where you begin to lose other contracts as well. So the mindset's got to be, you want to win, you want all your claims to get paid, you want to get paid for the product and the service and the work that you're doing. But where there are disputes, you want to approach them very professionally and in a collaborative way, because that'll help you to win and keep the contract, keep the business.
Okay, good point. As pharmacies, we have to continually go through recredentialing with PBMs. And this is usually every year, every couple of years. And the PBM will require us to fill out and submit a questionnaire. It's going to be lengthy, it's going to be intrusive, it's not going to be fun. But at the end of the day, we have to be absolutely honest in the answers that we give, because if we are not truthful, eventually that's going to come out. And when the PBM finds out that we've been untruthful, then it's going to term us and or may very well attempt to recoup payments. And so I'll give you some examples here in a minute. Okay, Scotty, next slide.
All right.
Now, here's some examples. Let's say that a pharmacy has a retail contract. Now, PBMs have their own mail order pharmacies, and they don't like retail pharmacies trying to compete with them. And so in virtually every PBM relationship that I've seen, well, let me back up for a second. With PBMs, you're gonna have a retail panel, you're gonna have a mail order panel, you might have a specialty panel. Retail panel is more common, and it's not a Herculean task to be added to a PBM's retail panel. But the PBM is not going to want the retail pharmacy to be competing with its own mail order pharmacy or with those relatively few other independent mail order pharmacies that are in its network. And so one of the questions on the questionnaire is going to be, for example, the extent of your mail order. ABC pharmacy does mail order comprise 20% or more of your total business? Well, if the pharmacy's operations, if in fact the mail order is 60%, then I get it. The pharmacy really is, would be inclined, or at least think about not being truthful and saying, well, notwithstanding that it's really 60%, I'm going to write down in the questionnaire that my mail order is 20% or less. The PBM is going to find out. And when the PBM finds out, then it's really hard to rehabilitate that relationship. The same is true with compounding. The PBMs, rightfully or wrongfully, have a real restrictive view towards compounding. Part of this has to do with the compounders several years ago that compounded the heck out of pain creams and then billed the heck out of TRICARE. And that gave the PBMs a black eye because they paid the claims. And so since then, PBMs have been very restrictive towards compounding. And so the question might be, do you compound? And if we do, but we answer it no, then that's going to come back to bite us. And then you look at the third sub-bullet, affiliations. Brad and I have seen clients, Brad and I are here in Texas. And there's an old saying in Texas, which is that cowboy is trying to stay ahead of the posse. Well, Brad and I have seen pharmacies where one pharmacy A will get into trouble with Prime or Optum or somebody. And so the owner of pharmacy A will go over and buy pharmacy B or buy an equity interest in pharmacy B, and then try to move the patients over to pharmacy B. So just trying to stay ahead of the posse. When we're answering a questionnaire, and if ABC Pharmacy, directly or indirectly, has some type of affiliation with other pharmacies, we just have to say yes, because that's the truth. Because if we try to hide the fact, that again, it's going to come back to bite us. Okay, Scotty, next slide.
And Jeff, I'll just point out, we see a lot of instances on a tax side where a pharmacy may not know they have an affiliation from a tax perspective. So that can, I think that's an important point there to be cognizant of
Absolutely.
that. What about, just
Brad,
real
I
quick,
know
what
that,
about the,
go ahead, Scott. I'm sorry.
where would delivery fall into this? Because I know some have talked to me about, they ask about delivery and how that may impact the mail order question, perhaps.
Yeah,
I don't know.
but it's
Just
good question. What, I might throw this back over to Brad.
Yeah.
What is mail order? Does that mean that, is that just USPS or is that UPS? What about Federal Express? What about Joe's Delivery Service? Brad, your thoughts?
Yeah, that's a relevant question, Scotty, that comes up in a lot of audits that we work on. And that is, to Jeff's point, a lot of these contracts limit the amount of mail order. They define mail order very specifically. And as the pharmacy, you want to pay a lot of attention to what exactly constitutes mail order. Under a lot of these contracts, it is acceptable to deliver by a courier or to a delivery driver or the like, and that may not qualify as a mail. That may qualify as a delivery, which the PBM might not have an issue with. The key thing there, what I always advise pharmacies to do, is continually review your contracts, but also all those updates that come in by email on Friday at 5:30 p.m. You got to look at those because a lot of times they will change the terms of mail order delivery, and you've got to stay on top of that. But in a lot of these contracts, Scotty, you can deliver, locally within the area, and that won't qualify as mail order. Some contracts even allow overnight mail within a certain area, and that might not qualify as mail order. The PBMs are looking for, a lot of distance to qualify, but it's all in the contracts, it's all in the updates, and the pharmacies have to stay on top of that.
Good. Thanks, Brad. Now, back in the day, when we as a pharmacy would either get audited by a PBM or we'd go through the recredentialing process where we fill out the questionnaire, it was pretty mundane. The only thing that the PBM was really focusing on was, are we truly dispensing what's being ordered by the doctor? Are we truly only billing for what's been dispensed? Things like that. But that's changed. It appeared, Brad and I, our whole law firm, in fact, we spent a lot of time defending investigations brought by the Department of Justice, state AG's offices, folks like that. And so we deal in the fraud arena quite a bit. What it seems like now, the recredentialing questionnaires are asking questions that we would expect the Office of Inspector General to ask, or the Department of Justice. They're very intrusive questions on our internal operations. So let me give some examples here. If you look at the slide, we've already talked about compounding, but then look at 2 and 3, marketing reps. Brad and I could talk for hours about the federal anti-kickback statute and their state counterparts. Bottom line is this: a pharmacy cannot pay commissions or any type of production-based compensation or income to a 1099 independent contractor, whether that's a warm body, a person, or a marketing company, if that person is generating, Part D, Part B, Medicaid, TRICARE patients to the pharmacy. Why? Because that violates a federal criminal statute, which is the federal anti-kickback statute. On the other hand, if that marketing rep, this person, is a bona fide W-2 employee, then the pharmacy has a whole lot more flexibility in terms of paying that person. Well, what's going to happen is most of these questionnaires then are going to say, hey, tell us about your marketing reps. Are they 1099s or W-2s? And if the pharmacy puts down, well, they're 1099s, then that's going to raise a red flag to the PBM that, well, wait a second, this pharmacy may be marketing in violation of the federal anti-kickback statute, and that might cause, probably would cause the PBM to term us. And so that's an intrusive question, but what that tells us is that as pharmacies, we need to be proactive and make sure that how we market is done correctly. The recredentialing will ask us about whether or not we're involved with any central fill arrangements. Do we provide pre-printed prescription pads? Collection of co-payments. Brad's going to talk about this more in depth, but this is low-hanging fruit. The law is crystal clear, and that is, as a pharmacy, when Mr. Smith, whether he's 42 years old or 72 years old, buys a drug from us, we say to Mr. Smith, thank you very much. We see you're covered by Part D or you're covered by Blue Cross. That's great. You owe us 20%, give us a check, pay us money. And we just can't routinely waive co-payments. If we do, then from the government standpoint, it's a kickback, it's an inducement, it's a false claim, all kinds of stuff. The recredentialing questionnaire is going to ask us about out-of-state licensure. Now, we might think that's just a kind of a milquetoast, mundane type question, but if I own Just Pharmacy and I put down in the recredentialing questionnaire that, hey, I'm not involved in any mail order, but then I put down that not only do I have a license in my home state, but I've got licenses in 5 other states, then that tells the PBM that, well, I am engaged in mail order. And so with these types of recredentialing questionnaires, we have to be careful. Now, Brad, let me pose a question to you, though, and none of these questions, folks, are rehearsed in advance. If you have a pharmacy client that is going to be, has made the decision, rightfully so, that it's going to answer a questionnaire truthfully, but in so doing is going to disclose that it is compounding more than what the PBM wants it to, or it is engaged in mail order more than it wants it to, or that your pharmacy client is marketing with 1099s when it should not be. How in the world do you handle that? What do you advise the client?
Well, that's a good question. So, and that's not uncommon that a lot of pharmacies want to get into a particular network or a particular payer, which has very specific requirements that might vary a little bit from a lot of the other payers, other PBMs. The first advice I give is you've got to be compliant. The safest thing to do is be compliant with your most restrictive contract, most restrictive PBM contract, because then you're going to be fine typically under all the others. To the extent that you've got different requirements and you're not going to be as strict as contract A requires with contracts B, C, and D, then keep track of the requirements of each, especially when you're signing on patients and you're going to collect their insurance. Be sure you're meeting the requirements of that particular payer to the letter, because if you don't and they audit these claims later on and you're not compliant, they're going to take you out. To the extent that some of these requirements might be onerous and kind of unachievable, it can also be a strategy to be proactive and reach out to the PBM to seek an exception to the rule when you contract with them. I've seen that occur on a lot of occasions where there's a particular reason a pharmacy might need to go outside the range for mailing or exceed the mail order. And I've seen a lot of those exceptions granted, but they're granted up front, not as an exception when you've been audited and they found out you didn't follow the contract. So it's just approaching the PBM, honestly seeking an exception, but my preference would be to find a way to get in compliance.
Okay. Next slide, Scotty.
We got a couple questions here, guys.
I'm sorry, Scotty. Brad and I don't do questions. I don't know.
I'll give it a shot. How about defined compounding? Is just regular mix of a couple of creams or a magic mouthwash considered compounding? Does that constitute a yes on a recredential? And I would, if I'll step in here. If I had to guess, I would say that is depends on the recredentialing application, but I'm going to leave it to you guys. You're the experts.
Brad?
Totally depends on you're absolutely right. Depends on the contract. They will typically define the terms that are in the recredentialing application, and you've got to look at those pretty carefully. So compounding in a lot of cases, I mean, we all know that, it's putting together, in many cases, a couple of different ingredients, active ingredients, with as many inactive ingredients as necessary to create a medication that's helpful for a certain condition. But all the compounders, all the PBMs, define compounding slightly differently. So do look very much to the contract. What I have seen, Scotty, are some audits where, and I'm not going to address the particular product the caller's asking about, but to give kind of a general example where the PBM says, we can see that you're providing this product, but it really was just not compounded, just, it's a commercially available medication that you're marketing as a compound. We're not going to pay for that. So I think if you don't want to risk a big recoupment on the backside, then the pharmacy should be very comfortable with and familiar with how the PBM defines compounding up front, especially when you're recredentialing. Because to Jeff's point, they're going to audit those claims at some point, even if just as a matter of routine. And if you're compounding when you say you're not, they're going to figure that out. You don't want to be in that position.
All right, Lee's saying he recently lost a high value patient to mail order. The patient said they would send her meds to her for zero copay. She was paying very little copay at my pharmacy. Are they allowed to do that?
No, I mean, and here's where it gets, and Brad, if I go off the rails and you disagree, then jump in. The law is clear. Pharmacies have the absolute obligation to make a reasonable attempt to collect the copayment. It doesn't mean they are successful all the time, and a pharmacy can waive it or reduce it on a patient-by-patient basis if the patient can show an ability to pay. But if pharmacy A is servicing Mr. Smith and Mr. Smith goes to pharmacy B because pharmacy B says, hey, I'm going to waive your copayment, I cannot think of any excuse or workaround or any way that would be acceptable. And so, and here again, let me kind of back up just a second. In fraud and abuse land, so much of the fraud that we see out there, whether it's just routinely waiving co-payments or stark violations or kickbacks, many of them are never outed. Many of them do not come to the attention of a government enforcement authority just because the government has limited resources. And so when pharmacy B is promoting, hey, come to me and I'm not going to charge you co-payment, then pharmacy B may never be caught. There's that possibility, and I know that's frustrating for pharmacy A. But if pharmacy B does get caught, then bad things are going to happen to it. And so the short answer is no, Scotty. Pharmacy B cannot be offering to waive the copayment if Mr. Smith is going to switch over. Brad, are we good?
Agreed. Yeah, a lot of the PBMs would call that an inducement, an improper inducement to get the business, and they would be concerned about that. So if that's what somebody in your industry is or your market is doing, then as a pharmacy, you may want to pursue that. The only advice there would be, if you're going to pursue that with the PBM or somebody, certainly be sure your own house is in order. So if they choose to look at your practices, then you're going to pass with flying colors.
Good.
He says it was her insurance mail order. Does that matter? The PBM is the mail order.
They in many cases, I'll keep this kind of general, manage to build in their own exceptions to the rule. It's a common complaint among pharmacy clients of ours that it's almost impossible to compete with the PBM mail orders. I'll just kind of leave it at that. I'll add one thing. A lot of states are passing legislation that restricts PBM's abilities to do that. Texas and others have begun, and in the wake of a decision called Rutledge that came out about a year ago saying that you can regulate PBMs, just kind of affirm what we all knew to be true. We're seeing more states begin to pass legislation that does kind of tighten the constraints on PBMs. And some of those constraints that I've seen, Scotty, involve PBM mail order pharmacies where they're being held to some of the same standards that they hold these pharmacies to.
One more question here, getting a lot here. What about 340B? Credentialing is starting to ask lots of questions on 340B contracts. Any advice on what you're seeing there? 340B.
General advice, sure, is again to be absolutely honest in submitting information, in filling out 340B applications. Understand what they're looking for, what the the most, understand what the most important information is on the 340B application. But again, just to be totally honest, we just cannot fudge the facts. That's the best advice I can give, Scotty.
I agree.
All right.
Okay, now we're going to be audited. Absolutely, without question. As a pharmacy, we may be the cleanest pharmacy in the world, but we're going to be audited, and that's okay. That goes with the territory. And so in preparing for an audit, we need to understand what our contracts with PBM say. What obligations are imposed on us. We also need to understand that our contract with the PBM might be relatively few pages, but the contract is going to say, there's going to be provision in there that where it incorporates all kinds of outside documents. Most PBM contracts are going to say that pharmacy agrees to comply with PBM's payment policies as set out in PBM's provider manuals and other documents. So we need to understand that we're agreeing to not only what's in the contract itself, but in these outside collateral documents. It's also important that when we as a pharmacy, when we are filling out a questionnaire for, we'll just pick on Optum for a second. Well, let's take a look at what we've said in the past. Let's look at prior questionnaires. Hopefully the facts will indicate that we are consistent. Certainly if in an earlier questionnaire we say, if in an earlier questionnaire we say one thing, but in a later questionnaire we say something else, then that can come back to cause some problems. Okay, next slide.
Okay.
There we go. Again, it's important, and Brad and I have already talked about this, to understand what the hot button issues are. And right now, the hot button issues for PBMs, in fact, Brad and I in the past have put on webinars on exactly these issues. But the hot button issues for PBMs are, what is the extent of your mail order business? If you're a retail pharmacy, how much mail order are you doing? Are you doing any compounding? Do you have any out-of-state pharmacy licenses? Are you collecting co-payments? And how are you marketing? And I call this the big five. And any one of these five can trip us up if we're not careful. And so we just need to understand that these are the hot button issues. Okay.
Now, Jeff, quick question here.
Yeah.
Total self-serving here, but if I'm getting audited, is it a good rule of thumb to reach out to the healthcare attorney and just run that by them?
Yeah, I mean, and I'm going to give a very self-serving answer. Brad and I are not any smarter than a local business attorney who really knows how to represent businesses, but does not have expertise in the pharmacy arena. We all have the same gray matter between our ears, same IQ, but it just so happens that Brad and I have been wallowing in the pharmacy space for a long time, and so we just happen to have developed an expertise. And so when a pharmacy is getting audited, yeah, I think it's important to pick up the phone, call a healthcare attorney and say, what do you think? And then we can, what we do is we guide the pharmacy as it fills out the questionnaire. And it's important because, I mean, attorneys are combative by nature. I mean, that's just, I guess you learned that in law school. I don't know. But a non-healthcare attorney might have the mindset of telling the pharmacy, well, the PBM is asking for things it shouldn't ask. You need to be tough. You need to refuse to answer certain things. You need to be fairly vague or general in answering other things. That's just not good advice. I get that might apply when there's just a business dispute between two non-healthcare businesses, but that doesn't work with a PBM. So it's worth a 20-minute phone call just to talk to an attorney. It's worth having the pharmacy fill out the questionnaire, but then send it to the healthcare attorney and say, take a look at it, make sure we're not putting our foot in our mouth. Brad and I just had a case with a pharmacy that it wasn't a recredentialing questionnaire, but the PBM asked for all kinds of information about how the pharmacy was marketing. Well, how our client was marketing was questionable. And so the client was kind of disingenuous with the answers, and that wasn't good enough. And so Brad and I had to help the client out to come up with clear, absolutely concise answers. Now, preparing for an audit as well, you know, it's not, our recommendation is to conduct limited self-audits throughout the year. These will be limited, they're not going to be large, but it'll be just give us an idea as to how we're doing. But then once a year, as a pharmacy, we may want to spend the money to have an outside consultant come in and actually perform a full audit. Okay, next slide. Now, it's important that we have a system in place to catalog all incoming information, phone calls, emails, texts, hard copy, mail. And Brad and I have seen this where we as a pharmacy may get a letter or get some type of communication from a PBM that says, hey, we want you to send us some documentation, we're conducting a desk audit, and it just falls through the cracks. And when it falls through the cracks, then that can really cause some problems. So let's make sure that internally we have our internal system set up. Next slide. We also recommend, we call it ART or Audit Response Team. Let's go on ahead and take the time to train some key members in our pharmacy to be the Audit Response Team. A person should be designated as the leader of the Audit Response Team. And so if a PBM representative, or, I mean, the same team could also handle Board of Pharmacy inspections or FDA inspections. But when somebody walks through the door and catches us by surprise, instead of having the deer in the headlight look, then we can direct that person to our Audit Response Team leader, who can then manage and coordinate what's going to happen on site. Next slide. This might sound awfully trite, but this is so important. Understand our deadlines. Just in fact, Brad, why don't you just talk to the folks here about the deadlines that come in and how it's so easy for a pharmacy to overlook them.
Well, a lot of times the audit will come in by email, and it might have a really short deadline. You get the audit on Monday, and the following Monday, the following Wednesday or Thursday, the response is due. Or it might say, 7 days, then you have to look through the letter to figure out they mean business days, or they might mean calendar days. You've got to get all that straight when it first comes in and calendar it with your team is the main thing, because it's really easy to mess up these deadlines. If you need an extension, I'll also advise you, ask for that extension pretty early on. If you've got an ESI or a CVS or an Optum audit and the results, your response is due on Friday, and you realize Friday morning, we can't pull all this together, we want an extension, and maybe the person that will give you an extension is out of the office that day. So you can either submit a really bad response, or you can cross your fingers and hope that they respond to your email on Monday and say extension granted. So if you want an extension, I advise pharmacies to get it pretty early on, to confirm that in writing and then calendar that deadline. I always tell clients, calendar the deadline a day ahead of when it really is, because many of the PBMs can't give you any leeway in the audits, otherwise they have to give those to everybody. So extensions are freely granted, but ask for them up front.
Okay. Next slide. Now, let's go back to attorneys. The reason that an attorney is important is that we are the objective outsider. I get it that if let's say an outsider came in to our law firm and looked at some of the Jeff Baird files and looked at some of the opinion letters I gave and emails that I wrote and starts questioning me about those. Well, I might get defensive. Human beings get defensive. That's human nature. Well, likewise, when a PBM goes to ABC Pharmacy and says, hey, tell us what you're doing and why you're doing this. Tell us about your marketing, your co-payments. Tell us about your mail order. Tell us about affiliate pharmacies. It's human nature that we might get a bit defensive, and our response may get us into trouble. And so the role of the attorney is to keep the pharmacy on the straight and narrow path, to make sure that the information that we submit is absolutely accurate. Because what we want to do is avoid the situation, which we've seen, where we don't want the PBM to say, well, wait a second, it sure looks like this pharmacy's done some really bad things, so we're going to turn our file over to the government. Or, the PBM might say, we think the pharmacy has done enough bad things that we're going to conduct an extrapolated audit. That is, we're going to look at a finite number of claims and then enlarge these based on an extrapolated percentage and ask for a whole bunch of money. We want to avoid those types of nuclear situations, and an attorney can help keep the pharmacy on the straight and narrow path.
Jeff, I'd like to add one thing there, if you don't mind, for just a minute. So there are certain kinds of audits that are worse than others, that have greater implications than others. Some examples include PBM fraud, waste, and abuse audits. And they're not all audits are FWA audits, but certainly more of those are now. Those are on a whole different level. The pharmacy is going to want to be sure that it devotes plenty of time and attention and resources to those audits. The caller a while ago asked about 340B. They have certain program integrity audits that's high level stuff. You got to get that right. So that's a place where you certainly want to involve an attorney, in my opinion. Any audit that's following on the heels of an investigation or any kind of disciplinary action at a state board, a pharmacy, again, high level. Any audit where you feel like if the response is going to cause you to get terminated or certainly disciplined, have to go into a corrective action program or the like, you want an attorney involved. On all other audits, what I advise, and I think Jeff does the same thing every day, is as an attorney, I like to at least eyeball the audit, the significant ones, before they go out, because I want to think about them, what they're going to look like down the road. If you have to appeal the findings or discrepant results, you don't get a chance to rewrite what you wrote initially. So if nothing else, I feel good if our clients run the draft by us and we get to check the boxes and say, I think this looks good, you're good to go.
Very good.
You want to avoid opening that can of worms.
Yeah, you do. You do.
Yeah,
and there's so many. There are so many audits that go awry that then become fraud, waste, and abuse audits, and the stakes are so much greater. I mean, everybody here on this call knows this, but you've just got to get those rights, those right. And so, at a minimum, I involve the healthcare attorney in those kinds of audits, especially if it says fraud, waste, and abuse. I mean, you just got to get an A+ in those audits.
Yeah, agreed. Okay, Scotty, next slide. Now, when we receive an audit as a pharmacy, we need to figure out what in the world is a PBM looking for. Sometimes the letter that we get from the PBM is clear, and we know exactly what it's focusing on, or maybe pursuant to a phone call we have with the PBM, we know. There'll be times when the PBM will be a little more evasive and just say, hey, send this documentation, we'll get back to you. But we need to do our best to figure out what the PBM is focusing on. And if it's not clear by the email or hard copy letter communication, then let's pick up the phone and call the PBM and let's see if we can get more information out of them. And then, as I mentioned before in the past, audits were pretty mundane. Did you dispense the drug prescribed? Did you bill for the drug that was dispensed? That was pretty much it. But go to the next slide, Scotty. And Brad and I have already beat this to death, but the audits today now resemble more like investigations. And so they're going to be asking us all kinds of questions that it's really, really important that we answer these correctly. Because if we don't, if we're sloppy with how we answer them, then as Brad mentioned, they can cause all kinds of problems down the line.
I'm gonna plug in a real quick example for you here as well that I saw just the other day in an audit. That was an audit that we call fraud, waste, and abuse, and the pharmacy called and sent that to me and was curious, why in the world are we being investigated for fraud, waste, and abuse? We tracked it back to the fact they had an inventory audit earlier in the year. That's a standard audit where the PBM says, all your wholesalers need to provide records of this particular drug that you purchased at all, so they know you had it to dispense. Turned out one of the wholesalers didn't respond to the inventory audit. The pharmacy didn't do its diligence to know that. So the PBM crunched the numbers and concluded you couldn't have had enough product for everything you billed us for. It became a fraud, waste, and abuse investigation. We were ultimately able to go backwards and prove, once we got the other wholesalers' records, to prove we did have enough inventory, and the result was good. But the point was, what started off as a basic audit turned into something pretty bad. So one tip I might give pharmacies here today is that if you're involved in an inventory audit, just to prove that you've got enough product, be sure all your wholesalers are responding. Reach out to them in writing, or call them and confirm they're going to respond, because if they don't, then you may find yourself in an FWA investigation a couple months down the road.
Smart. Okay, good. Okay, Scotty, next slide. We've already covered that. Let's look at the next one.
Mm-hmm.
And we've covered that. Let's go to the next one. Okay, Brad, I think you've got these next set of slides.
Sure, thank you. So, and again, I'll echo our thanks to you, Scotty and Alan, for allowing us to participate in this webinar. I love these presentations because we get to talk about what we do every day for pharmacies, hopefully helping your audience to answer some of their questions. Legal compliance, collection of co-payments. This is a big deal. We've talked about it. The main thing there is that you need to collect the co-payments. If you don't collect them, it's got to be pursuant to a case-specific individual assessment that that patient can't afford to pay the copay. You've got to have sufficient evidence and documentation to support that, because you will be audited. What will happen is this: the typical audit comes across to your pharmacy and they ask for proof that you collected co-payments from these 20 patients. So if you can't provide it for 5 of them, suddenly it looks like you're not collecting 25% of your co-payments. The PBM has serious regulatory concerns about that. You may be termed. So it's important to collect the co-payments, or to be able to demonstrate to the PBM that you attempted to and why you couldn't. It's also important to take a look at the specific PBM's requirements. Some require you actually obtain documentation that you have in your file to prove inability to pay. Others are satisfied with something less than that, but they all do require diligence. So no routine copay waivers. Where you do it on rare occasions, you've got to have the file materials to support that. Next slide, Scotty.
So Brad, a question. How can we prove that we have the co-payment documentation? What do you recommend?
Yeah, so the gold standard, and not everybody can do this, Alan, but the gold standard is you've got, for each one of those patients, you've got a little file. It can be electronic, but you've got a file in your system regarding their co-payment. If it's collected, maybe you don't need an individual file because you can prove that easily enough. If you can't prove it, then you've got this file right here, it can be electronic, that demonstrates that you asked them all of these questions. This is how they answered them, that they provided you this documentation. You did an assessment individually of that patient's inability to pay because they're below the poverty line or they satisfied your standard, and you didn't collect the whole copayment. But one point here, if you can do it, you collected some of the copayments. Maybe the copay's $25, which those of us here could pay $25, but a lot of people have a hard time paying a $25 copay, especially on a recurring basis. So if you only collect 10 because that's all they can afford to pay, the documentation's got to prove it. So individual file for each patient for whom you waive any part of the copayment. That's the gold standard. Alan?
What about charge accounts and then you write off those accounts 3-6 months later? Is it more along the lines of how you follow up and documentation on how you're following up on collecting that?
Bingo, Scotty. So to the extent that you're writing off a charge, which it's really, from a lot of PBM's perspectives, it can be problematic if you keep If there's a charge account, meaning that you're on a recurring basis waiving copays, that can be a challenge. I've certainly explained that away with specific facts, but everybody should know that's something that can cause the PBMs some concern. If you're going to write that off, though, you want to do so based on an individual assessment of uncollectability, which, to Alan's point earlier, that needs to be documented in your file. So what I like is if we have an audit, and the example I gave a minute ago, we have 20 patients and they're auditing on the co-payments. So maybe we collected 17, but we have 3 that were anomalies. I want to file for each of those 3 indicating what it is that we did, and they were all based on an individual assessment. Those audits are usually going to turn out much better than those where we're sweating bullets on Friday afternoon before we reply to this audit because we don't know what happened with those 3. So it's all a part of the underlying business process of the pharmacy to collect co-payments, or to, if they don't collect them, to be able to justify it internally. Great question. On marketing, the key thing I'm going to say here is that most pharmacies have a sales representative or some kind of a marketer. Let's say that your pharmacy has operations in multi-states and you have a sales representative in each of those states. So maybe you have 4 sales representatives around the country for your pharmacy. Each one of those individuals, in our estimation, needs to be a W-2 employee, not a 1099, to avoid kickback concerns. But even a couple of tips there. I advise pharmacies, Jeff and I tell pharmacies all day long, if you're going to have that arrangement with the sales rep, the gold standard is to have a written employment agreement that explains what they're doing, that if a PBM looks at it or investigator looks at it, you're proud of it. It should include generally a base salary. You can pay commission in most cases, but we advise against a straight commission payment to sales reps. I like to see more of a base salary. That's at least the gold standard. To the extent that you do any any marketing with any 1099s, any companies that market for you, perhaps they do online advertising and the like, I want a written agreement that's been vetted by Healthcare Council that meets all the safe harbors to the kickback statute, so you're good to go. So just be wary as a pharmacy if you're marketing. If your sales reps are going to see physicians, you want those arrangements very carefully documented and vetted by your healthcare attorney. Kind of the last point there, and Jeff mentioned this a minute ago, these need to be bona fide employees, these sales reps. They've got to come to the home office for the annual meeting. They've got to turn in their timesheets or the required records. They've got to sign off on the handbook. They need to look like all of your other employees so that if you're scrutinized, you'll pass that test.
And Brad, also, if you're marketing in multiple states, you have to make sure you got the income tax issues covered where those employees are working in those other states. Many pharmacies are not doing that. We run into this constantly. It's a huge tax issue.
It's a great point, Alan. That's a great point, and it isn't one size fits all. So if you go multi-state, that's great. That's a great model. We work with a lot of pharmacies that have that model, but consult with Alan and Scotty, your professionals, to be sure that you've got that part of it covered right. Consult with your healthcare legal counsel to ensure you've got that part covered as well. We've already covered the affiliate pharmacies. I'd like to go ahead and skip that one. I'm going to move on to a couple of others. Yeah, here we go. So legal compliance and disciplinary actions. A lot of times the PBMs will ask, have you been disciplined? Nobody likes to answer that question if the answer is going to be yes. If the answer is yes, our advice is answer that question truthfully, but explain. It's not uncommon for a pharmacy to get dinged in their local board of pharmacy for a $1,000 fine or a $2,500 fine because they did something that isn't significant. It didn't jeopardize patient health, but it violated some rule or regulation and they get dinged. The PBMs can find that. They're able to get online and figure out who's been dinged. So they may pull your file when you're recredentialing and you've said no and look to see whether the answer is actually yes, and then term you for lying to the PBM. So certainly you want to be able to provide that information truthfully, but feel free to explain. Also, one thing I'll add here that we do a lot of board pharmacy work, representing pharmacies that are addressing board issues. Even if we do it behind the scenes, it's important that you pay attention to the board matters, because if you do get dinged, it can affect your PBM contracts and the dominoes can fall. So pay attention to all the board actions. If you're going to say yes, plead guilty to a $2,000 fine before the state of Pennsylvania, state of Texas, state of Oklahoma, anybody else, be sure you know what the repercussions might be with the PBMs. The next slide we've covered pretty well. Know that that there are a lot of these, I'd look at this one after the webinar, if I were a pharmacy here. These are a lot of the very specific kinds of questions that are compliance questions that PBMs do focus on. Pre-printed prescription pads, we see that a lot, not only in the PBM world, but when a pharmacy is being reviewed by Department of Justice or a state agency, they're looking to confirm that your order forms and the like comply with your state's law. So be sure you have vetted all that. Next slide is on certification. And they're going to ask you to certify the answers are correct. Obviously, give that a lot of thought to be sure that you're following the law there, because when you make that certification, that can be used against a pharmacy if you provided something that was less than completely accurate. Few tips here with the last few slides. Review the documentation to be submitted. That sounds pretty basic, but I'll tell you it's not. It's not. It requires a lot of work. It requires that your pharmacy has an audit response team, or at least an individual with primary responsibility for responding to audits. If an auditor gets your file on Monday morning to see your responses to the audit, it better flow really well. There should be a cover letter. It should be organized. It should be indexed. It should be clear as day what it is that the pharmacy is providing to prove they complied with all the PBM requirements. If it's not clear as day, that's not a good audit response. So be sure before it goes out that you're very, very satisfied with that. A lot of times it's a good idea to have your healthcare lawyer just eyeball it to be sure they wouldn't want to tweak a little bit of language before it goes out. That's certainly true on appeals. Certainly true if you have like a park audit or any kind of a provider audit where you're going to be testifying orally to the PBM. You want to be sure you're well prepared for those. Those are part of the audit process and can make or break a pharmacy's participation in the network.
Yeah, we do that with the IRS. You make it as absolutely as easy as possible for them to follow along and get it out the door.
Exactly. It sounds basic, but it's so important. So many audits, we get hired on appeal by a lot of pharmacies, and you look to see what was submitted in the underlying audit, and I just know that our work's cut out for us because it wasn't an A+ product, and now we have a lot of things to explain.
That's very important. Yep.
Just always tell the truth.
Exactly right, Alan. Always tell the truth and explain. If telling the truth makes you kind of red in the face because you have to tell something bad about your pharmacy, there's a good reason for it. So Jeff and I have done some where maybe we had a bad employee. We had somebody that we ended up terminating because they dropped the ball on some audits. I've explained that before to the PBM. We had an issue here. Here's the mistake that was made. We had an employee. We dealt with the situation. We've resolved it. Here's what we want to do to fix this thing. And so we tell the truth, but then we try to explain it to rehabilitate the pharmacy. It's important to do that. Next slide. We want to organize the files, and tell a story. Yeah, tell a story about the pharmacy. All the pharmacies here on this presentation today have a story to tell. A lot of pharmacists are self-made people. They worked hard through school. They work hard as pharmacists. They work hard for the business that they own or the business that they manage. So tell the story about your pharmacy, not for 2 or 3 pages where it's overwhelming. Make sure that the PBM understands who you are and where you're coming from, because that helps to personalize you to them. Next slide. If you have bad documentation, rehabilitate it, explain it. If you get an audit and you got a lot of medical records and you really wish you had better medical records, then go get that fixed. Go deal with the provider, the physician, his or her office. Get better records to supplement what you all know to be true. This is a lawful prescription. It was medically necessary. We dispensed it, but we don't quite have the documentation we need to support the audit response. Get it now. Get it so you can respond well to the audit. If you don't do it in the first stage and you have an adverse finding that you've got to appeal, then go get it. I think it's so important that if you maintain good relations with all the doctors and providers who refer business to your pharmacy, keep an open line of communication. You're going to need their help. You're on occasion, you have to call them and say, would you please do an attestation for me? Would you sign one indicating that you made these prescriptions, you provided those to our pharmacy for these patients and they were medically necessary for the reasons that you told the patient. If you have a good relationship, they'll say, I'm not thrilled about spending time doing that, but I'll do it for you because I care about the patient, and they'll do that for you. So rehabilitate where your documentation might be lacking. Next slide. Tell the story. Tell the story of what happened. If you made a mistake and you're on appeal, tell what happened, explain it in the best possible light, provide documentation. Consider something, Jeff and I do this all day long with pharmacies, consider offering a corrective action plan to ensure this won't happen again. Take steps to mitigate the damage before they actually terminate you, because most PBMs termination appeal procedures are pretty lacking for a pharmacy. It's really hard to get back in once they've booted you out. So the better thing is to figure out a way by telling your story to stay in. Next slide, copies and explanatory letter. Be sure everything you submit to the auditor, you've got a complete copy of that. Because if you get a discrepant result or something you need to appeal, you want to know exactly what you provided them. To Scotty's point earlier, the explanatory letter is so helpful. Put that with your documents so that anybody who doesn't want to be reviewing your files can read the letter and understand exactly what they're looking at. And if we're involved as the lawyers, in most cases, I'll ghostwrite that letter for the pharmacy. It's going to come out on pharmacy letterhead unless there's a really good reason for it to come out of mine, which isn't the case until you get to maybe some termination provisions in most cases. The next slide, follow up with the PBM. Be sure they got your documentation. Be sure they know you responded. If you haven't got any confirmation, then get the confirmation. Another benefit here, kind of a tip, is if your audit response is due on Friday, man, I would not wait till Friday to submit that. I would submit it on Wednesday, Tuesday, Thursday if you have to, and then follow up to be sure you confirm they received it. When you get an email reply of any kind confirming they got it, save that in your file. You don't want to be termed down the road because they think you didn't provide a response.
Got a few questions here. I think on the credentialing, here's one about regarding lease term. They were asking about owner name, address, months of lease, dollar amount. Can they ask this?
They do ask it, so the answer is they probably can. I don't mean to be flippant. The point is, I don't ever like to argue with a recredentialing PBM. You can't ask this, or this is, none of your business. That's not that doesn't work well with PBM. So the answer generally is yes, they can ask that. We typically provide, I'll tell you why they ask that in a lot of cases. A lot of cases they ask that because there have been stark issues that have arisen over the year where the PBM has a pretty cozy business relationship with the referring physician. Maybe they lease space from them and pay well more than market value, and then they get a lot of prescriptions from that physician. That's the exception to the rule, but the point is they want to vet those relationships. That's why they're asking for those documents.
There's one question here, one more. I've been audited by PBM over some type of gel I can't pronounce on day supply. I put 30 days supply, but PBM said it should be 25 days and they recouped the money. Is that legal?
It's a good question and a hard one. It really depends on what your documentation said about day supply and what quantity was dispensed. It's a pretty specific question. I would probably run that by your healthcare attorney, especially if you're on an audit, because the concern here is if you don't answer it the right way, then they might claim later on you're misrepresenting what it is you're dispensing, and that can become quickly a fraud, waste, and abuse investigation by the PBM. So I would take that one to your healthcare lawyer and get some advice, because that's pretty tricky stuff.
All right, real quick, RX assessment service. This is a service that Sykes & Company we have here, and what we do is we take your accounting and tax information, we overview that internally, and give you third-party feedback on your current accounting and tax situation, and give you a roadmap of actionable items we see that you need to implement, or things you're doing well, or so on. So you can go to our website, sykes-cpa.com. The very top of the homepage, you'll see RX assessment. You just click on that. It'll walk you through everything. There'll be a short video on that. We'd be happy to help you out any way we can there. Just a quick disclaimer, this is educational purposes only. And then here is Jeff and Bradley's contact information. They've been great partners here with us. They do great work for a lot of our clients, and we certainly appreciate them being on the webinar today, and look forward to seeing you guys out on the road, hopefully sometime soon. Jeff, Brad.
Absolutely, guys.
Hey, thanks, Scotty. Thanks, Olin and Brad. It's always a pleasure, and all I'd say, folks, is continue to work with Scotty and Olin and their team. They're the best. So thank you for having us.
Thank you very much.
Thank you, guys. All right, take care.